gives me extreme pleasure to welcome all of you to the second Azim Premji International Conference in Law, Governance and Development. It gives me extreme pleasure as well to have Professor Siri Gloppen to give the public lecture. For some of you who actually don't know her work, I will try and sort of introduce her. Professor Siri Gloppen is a professor of comparative politics at the University of Bergen, senior researcher at CMI, director of Bergen Center of Law and Social Transformation, and a research coordinator at the Pluricourt Center of Excellence, University of Oslo. Her main research focus is on the role of law and legal institutions in the social and political transformation, spanning issues such as legal mobilization, enforcement of social rights, climate governance, constitution making, judicial politics, and transitional justice. She has directed a number of comparative research projects in these areas, resulting in several books and articles, including the most recent one, which is titled Juridification and Social Citizenship. There are others, Litigating Health Rights, Can the Courts Bring More Justice to Health, Law and Power in Latin America and Africa. Today's talk is entitled, Can Courts Bring Social Justice? Rights-Based Welfare Policy in Comparative Perspective. The talk, in light of diverse experiences around welfare rights over the last 2 decades, will ask the following set of questions. What difference does it make that social policy is right-based? Does it make courtrooms central sites of welfare policy? And if so, how do judges deal with these deeply political issues, and to what effect? And does it matter whether welfare rights are provided constitutional protection or just laid down in ordinary legislation? By examining experiences from different parts of the world with regard to legal protection of welfare rights, the talk provides perspectives on the potential limits of court-based enforcement as well as out-of-court rights-based strategies. Indian developments will be compared with experiences from Latin America, South Africa, and Scandinavia. So I welcome Siri Gloppen to come and deliver the talk.
For a generous introduction, and thank you, Sudhir Krishnaswamy, for inviting me, and thanks to the Azim Premji University and Foundation. It's such a pleasure for me to be here, and I was looking forward to coming, but today has been just exceeding my expectations in terms of intellectual engagement. It's been really, really, really good. And I'm very impressed to see that so many of you have the stamina to stay for another session. I hope we can have a good conversation after I've given the talk. So I want to start where a lot of the issues that have been discussed today will be sort of resurfacing in the talk I will be giving in the beginning, and then hopefully what I'm saying can also inform what we'll be talking about tomorrow. But it's also important that those of you who have not been part of it today and will not be part of it tomorrow can benefit. So if I should be too convoluted, please raise your hand and let me know, and I will explain, because it happens after a long day of engaging and thinking. So India has particular challenges, social challenges. In a recent article by Alkira, Rocha, and Samna, entitled "Where Do the World's Multidimensionally Poor People Live?" that some of you might know, they say that if you look at multidimensional poverty, health, education, and living standards, 40% of multidimensionally poor people in the world live in India. And 40% of the severely poor live in India. So India has particular challenges on a global scale. And also in the much discussed recent book by San Andres, they show how India compares very poorly on some very important welfare indicators with poorer countries. They compare them with the 15 poorest countries in the world outside of sub-Saharan Africa. And as you can see, all of these countries have a lower average GDP than India has. But still you can see that India compares poorly on these figures. They're below, so they're in the lower half on several of these, including on under-5 mortality rate, underweight children, stunted children. And then you can see that it's very low compared to the average on access to improved sanitation. So this is happening despite the fact that India has had 2 decades of robust growth. So it is a situation of poverty amongst relative plenty. Although, of course, India is a lower middle income country, it is particularly a challenge of redistribution, as we've been talking about today, and as I'm sure you all know, but I think it's still a good place to start. Because I think what it shows us is that the political dynamics are, that redistribution in India is up against very exclusionary political dynamics. If you think about the escalator if you think about the escalator going down, it's going quite fast and at a heavy pace, leaving people down. So the question is, how do you either get up on the escalator or manage to turn it? Because and that's something that I'll come back to later in the lecture, that would be sort of the general theme. Because I think we were talking earlier about the Norwegian welfare state. I come from Norway, and Norway has, as most of you know, a welfare state where the social rights welfare rights are materially protected in the sense that most people have access to all the services that welfare rights should protect. But it's actually a situation where the legal rights are relatively weak to welfare, and particularly at the constitutional level. Actually, we're debating right now whether the Norwegian constitution is 200 years next year. And as part of the 200-year celebration, there will be a constitutional amendment and probably more social rights included in the constitution. So this is a reversal. Sort of, it's there in material sense, but the legal protection is now being discussed. Of course, the fact that Norway is part of it has the European Convention of Human Rights has become part of Norwegian law. So there is a sort of constitutional protection, but still it is in a way a reverse. It's a reverse situation where rights are being promoted to cap or preserve rights that are materially there to a large extent. Although, of course, there are groups whose rights still are relatively weakly protected. But in India, the situation is then the opposite. The situation and the question today is whether welfare rights, rights to education, food, work, social security, health services, healthy environment, whether these types of rights which have now, to a large extent, in the last decade, been put into statutory law in India. In the Right to Education Act, the Rural Employment Guarantee Act, now the Food Security Bill and Ordinance, which is sort of giving legal force to these rights, whether this can actually make an inroad, whether it can either sort of help more people climb on the escalator, or maybe turn or lower the pace or do something about the pace of the escalator itself, do something about the social dynamics. And my sort of main argument in the lecture today is that I think that comparative experiences indicate that welfare rights can have a transformatory role, but it depends very much on the way it engages with political dynamics. And I'll show that by going through the experiences in different places. So So coming from a country where the courts have no role, basically very, very little role in relation to welfare rights, this I'll look at how this has played out in particularly Latin America and South Africa. But I'll start by saying something about the function of welfare rights. What is the hope? What is the function that these rights have, that the dynamics that we're hoping to gain from them? And in my perspective, these are related to four different functions. Two of them are related to the role of rights as pre-commitment. So welfare rights commit the government to prioritize welfare, to prioritize the right to education, to prioritize education, food, the content of the right, before other types of spending. That's in theory. Sort of in principle, that's what welfare rights as rights mean. So it's a welfare commitment. It's also an equality commitment. As rights, they are, we've had a discussion, and it's not, in practice, it's not just true that all rights that are in welfare legislation applies to everybody equally. But welfare rights, in theory, are rights that citizens hold as citizens. And they hold them equally given, and they are released under certain conditions. And they're based on the state's obligation to respect, protect, promote, and fulfill socioeconomic rights. And they provide the material basis for life with dignity. So what we hope that they will do is that they will provide a push towards equality. It's a commitment towards equality. So the function of rights is that the commitment to welfare is beyond improving averages. It is a commitment towards universal coverage. Some of you might know this figure. It's from the World Health Organization, and it shows the challenges of moving towards universal coverage. This is health, but it goes for many social services, that you need to extend along 3 dimensions. You have to extend to the non-covered, which is priority, based on the equality for commitment. And then you also want to include quality and more services. And then it's also about how much people should pay for services. You want to, in health particularly, reduce cost sharing and fees. But the question and the dilemma is, how do you get the funds that you have to extend, and what should go first? So welfare rights apply to all these dimensions, but the equality commitment in welfare rights make a strong argument and a strong push for extending to the non-covered and towards universal coverage. There are 2 other functions that I think are important to think about in terms of welfare rights, is that rights are basis of claims. Rights provide, they provide claimability. The individuals can have a basis for claiming rights, or groups have a basis for claiming rights, and which means that it's agency enhancing. It enhances agency, and it enhances social citizenship and voice potentially. And that's the function one of the functions that we're after. And it's also enforcement enhancing, because when welfare rights mobilize an additional enforcement apparatus, including the courts, which is what we'll look at. So it has the welfare commitment function, equality commitment function, agency enhancing function, and enforcement enhancing function. And I think all of these have been discussed in different ways today. And in practical implementation, they're tweaked and restricted. But that's sort of the ideal that welfare rights contain. So my point today is to show that when we think about the role of rights in social transformation, we have to think about it both in terms of the political process, and politics is in many ways the highway of social change. That's the engine room. That's what is driving the escalator. That's what those power dynamics must change to some extent, or they must change if the pace is going to slow or the escalator is going to turn, because that's what's driving the exclusionary social dynamics. But then you have legal avenues that interact in different ways with, or can interact in different ways with the political avenues. And there are big debates, and we've had these debates today, about whether the rights actually are helpful. Do they represent a shortcut? Is it possible to sort of get to welfare rights in an adverse political climate through a legal process, or is it a blind alley? Is it something that maybe is useful in the short term, but not really bringing change in the long term? And these are really crucial issues that we need to think about, because a lot of energy is going into legal mobilization. But I also think it's important to think that it's not an either-or. It's not either political or legal. That there are legal-political relations and trigger mechanisms that we need to explore more closely. And so I will focus in particularly to legal routes to political change, trying to sort of look at that legal-political interface. So I think that when we think about legal strategies, there are two main types of functions that legal strategies play. One is that they try to close an implementation gap in relation to welfare policies. So when the policies are in place, courts are used in different ways to try to make people get what the laws promise. So that's closing the implementation gap. That is something that courts and other types of institutions, often internal mechanisms, institutional mechanisms do in most countries, and it's not particularly controversial. The other function we might call policy gap. So that's when the policy in question is challenged for being out of step or not corresponding with the right. So the policy should be changed or new policy should be made. So that's the policy gap. So, and across these, both in terms of implementation gap and particularly in terms of the policy gap, there are a range, and I'll come back to that, there are a range of different types of legal actions, of course, that can be brought. And I think we should look at this broadly, not only looking at rights litigation as such, but also administrative action, particularly in terms of implementation gap. But depending on the different legal systems, these can be individual claims for benefits for themselves. It can be public interest litigation claims for individuals or smaller groups. It can be litigation for broader legal change, policy change. And it can also be litigation as a supplementary tactic for long-term political strategy for social change. So this is the sort of map of what I'll be looking into. And now I'm going to take you through some of the theoretical apparatus that I'm going to use. So please, if this if I'm going too fast, let me know. But what I will, I'll take most of my examples from the comparative work that we did on litigating the right to health in different countries, because that brought up a lot of very interesting legal political dynamics. So not all my examples will be from there, but many of them will. And what I will be doing is that I will look particularly at how different actors involved in litigation processes, people who decide to litigate, the people who litigate on their behalf, judges, and also political actors, how their action is conditioned and constrained by a particular choice situation or opportunity structure, and how the different actors, opportunity structure, influence each other in these processes. So I'll probably go a little bit back and forth, but this is how, can you hear me if I talk like this? Maybe I'll, yeah. So what I think is interesting is, and important is to, when we try to understand the role of courts and adjudication in processes of social change, we need to look at how they interact with other actors in the process and try to understand the mechanisms, try to understand how they are what influences them, what makes them do the judgments in these cases in a particular way, what makes them decide. To what extent does it depend on what the litigants are bringing? To what extent does it depend on internal factors in their training, the way the professional ethos is working out? What determines whether their ruling have a political impact or not? And what determines implementation and effects. So my point is that I think it's very useful to try and put yourself in the position of each of these actors, trying to think about how these processes play out. And if you go back to the format, so these are each of these stars. This is the star. This is each of these stars. So this is the decision. So what actors decide to do depend on the barriers that they face and the resources that they have available. And these are of many different kinds. So some of them operate on what is sometimes called a logic of consequence. You think about strategically. What happens if I decide this way, what will happen to me, to my situation, my organization, and so on. But there is another logic as well, which is what is the right thing to do in this situation, and what is the proper thing to do, and that's the logic of appropriateness. And I think it is important for all of these actors to try to realize that there are different types of considerations that the actors make, and that they vary between contexts. And it's particularly this is looking at the different considerations that litigants take when they decide how to mobilize for what they want. Whether they want to press a claim in court, or whether they want to go a political route, or both. So it will depend on, is the political system responsive or unresponsive? And that is a very important consideration. And I think that others equal, and if we look at where in the world courts play a particularly important function as an arena for mobilization, it is in countries where the political system, for some reason or other, is quite unresponsive to these groups. Social and political inequality can play an important role as a barrier, depending on where you are in the hierarchy. The legal opportunity structure is important. How easy is it to get to court? What is the rules of standing? Who can bring a case? Well, how easy is it to access the court? How formalistic is the process? But also, is there a form of human rights protection? What can you expect to get? What does the law say? How costly is it? Is it in a language that the litigants understand? All of these factors play in, and they vary enormously. They vary enormously. If you want to bring a case in Costa Rica to the Constitutional Court, it doesn't cost you anything. You don't need a lawyer. You don't need to write it in a particular way. The court has the clerks. If you send in a claim, the courts have the clerks who will see whether you have a case and make the case for you. In Colombia, it's very, very easy. The threshold is very low. In most countries, of course, the access to justice is more difficult, and that, of course, has a lot to say. I mean, that impacts the actor's decision on whether to take the case to court or not. And of course, what also matters is whether what is the track record of the court? Are there reasons to believe that your claim will be supported? And then also, what kind of is there legal aid? Are there organizations litigating on your behalf? So which resources are available for the legal process vis-a-vis the political process? So it's not only about the barriers, because even if the barriers are high, if the resources are there, you can go. And maybe you have the legal resources, but not the political. For instance, if you're a stigmatized political group, even if the barriers are high, you might want to go the legal route, because it's easier to get the legal legal support you need. So, but if you have strong social mobilization capability, political strength, connections, media support, you might want to go political route, or you might want to do both. So this is I think one important driver of this process of litigation. It's trying to look at what are the opportunities that people who mobilize in these situations have. Yeah. Yes. So I'll start by showing but telling a little bit more about the process that you have in Latin America with regard to welfare claims. You have, as I mentioned, many of these countries, in particular Costa Rica and Colombia, but also the other countries have very low thresholds for bringing cases to court. And it means that you get a lot of cases. In Colombia, only cases regarding the right to health, you've had up to 150,000 cases a year claiming health services in the courts. And Colombia is a little bit smaller than the state of Karnataka. So it's a lot of claims. And these cases regard both what I was talking about as implementation gap and policy gap. In Colombia, there is a right to health. There is that's in law, but there is not a right to health there is a right to health act, but there was not a constitution provision. There was directive principles, but not the right to health in the constitution as such. But the Constitutional Court of Colombia constructed the right to health on the basis of the right to life with dignity. The same was the case in Costa Rica. And the litigation on health spiraled, so it increased every year. So we had lots and lots of cases. And many of them, more than half, were concerned implementation problems. And one of the reasons was that in the Colombian system is a system of managed competition. You have private insurance companies being paid by the state to provide health care. There is a state health fund. Those who can contribute and are in a particular scheme. And the others who couldn't contribute had a smaller package. But it was a lot of public funding going into health, but there were private actors managing this. But that also meant that there would be a lot of private interests in non-compliance. Because if I'm a patient and I want an expensive treatment, the insurance company might want to try and say no, even though they're legally should provide it. You know this from the States, so it's the same logic. Only that this is public funded, and some of them are public. But so then you have to go to court. It's quick, it's cheap, but you have to go to court to get an order, and then you get it. So a lot of the cases are like this. So it means that access to justice becomes part of the access to health. But a very high percentage also concerned resources or things that were not in the package. So there were health services that the state had decided not to pay for. And then people would still go to court. So people who were in the subsidized scheme, they would go and ask for things that were in the contributory scheme or things that were outside, but mainly people who were in the contributory, the more wealthy, they would go in formal employment, they would go and ask for things that were outside. The majority of the litigation, that type of litigation is from there. And then, so what then happens is that, and generally, a very, very high percentage of the cases were granted. So what then happens is that you get a lot of healthcare spending that is authorized by the courts. And this happens also the same happened in Brazil and the same happened in Costa Rica, but the political reactions were different. So in Colombia, even if an insurance company was sued or a case was taken, it's taken to the government as constitutional case, but even if it's taken 100 times, nothing will happen because there is no interest in changing, including more in the package. They would rather pay one by one. But in Costa Rica, the government would include it in the package. After a few cases, it would be included. So then it would expand policy. It would be equal for all, but it would mean a more costly health policy. In Brazil, it varied, but in São Paulo, where there was a lot of litigation, the government actually had to establish particular pharmacies to hand out the drugs, and more than 100 people worked in the bureaucracy of the state of São Paulo to administer these claims. So this was really, really large. So these are the individual cases. And then the question is, does this make healthcare more or less just? And it's very difficult to actually measure. It's difficult to see the social profile, but indications are that it's not the poorest, even though access is really, really easy. The people with more resources are more prone to go to court. It's not also poor people go, but they're more prone to go. But if you look at what they ask for, what is typical is that what is being litigated is very important, is expensive drugs for very serious diseases with quite limited effects. So it is a question whether this litigation is really advancing the right to health on the larger scale. But at the same time, it does help certain groups who really should have the medication depending, sort of, if you compare it to the effectiveness to that of other groups, such as HIV patients and so on, at various stages. So it's ambiguous. But that is one very important and numerically the largest part of the litigation that we saw. And what you see is the fact that access is easy and judges will grant. Almost everything will be granted. That means that there will be more litigation. So you get the feedback into more litigation. What you see by comparison in South Africa, where there was the first, so many of you will know it, Supermuni, on dialysis treatment, which is expensive and which goes on. So it's a long-term treatment. And what the court said in this case was that there isn't enough for everybody. And we don't want to be a queue jumping station. We don't want to move people along the queues. But we will ask whether there is a reasonable policy in place, reasonable criteria for rationing, whether the resources are being used effectively, and whether the criteria are being followed in this particular case. And then the conclusion was that this person could not get the the treatment. And of course, that really changed this dynamic, because that meant that there was a lot less push for people to go and litigate for health services in court. So that shows how these dynamics depend on many things, but they depend access is also much more difficult in access to courts in South Africa. So that's another point, but it's clearly one. It's clearly one factor that was very important not to get that particular type of litigation on a large scale in the South African situation. Yeah. So then we see that these type of cases, they influence. And now we've seen sort of on the influence on litigants, but they also influence politicians. So in Latin America, and particularly in Colombia, there has been a really growing tension between the health politicians and bureaucrats and the judiciary on these issues, where the judiciary is seeing the politicians as not sort of in good faith, and politicians have also. So there has been a rising conflict, and I think that it's. But at the same time, it has in Colombia. It for a long time meant that you didn't really have to update the package of health services or change the policy because the steam was sort of in a way being let out in the courtroom. So it influences on dynamics. But then there are also other types of legal changes where as I said, the litigation is not only for an individual treatment or an individual service, it's for a change of policy. And we've seen that's a typical public interest litigation case. And we've seen that India has many cases, as you know, but in South Africa, there has been a lot of, or several famous public interest litigation cases in many areas that we've heard before, and also in some Latin American cases. But what we see in these cases is that they are generally, and then, for instance, in South Africa, they're generally quite demanding for the litigants and the litigators. They require a lot of research, engagement with political actors. They often involve quite a lot of out-of-court mobilization of different groups. And there is a lot of, often arise a lot of media attention. So there are a lot of different factors that then, they bring a lot to court, if you want. They bring a lot of very sophisticated arguments, for instance. There are cases on HIV, on mother-to-child transmission of HIV/AIDS is one important case, on the right to housing. We've heard earlier today on social security cases. And generally what you see is that they bring a lot to court, and the court relies on the arguments from the parties, and also amicus, the friends of the court, who bring arguments, and they make quite sophisticated rulings, and have developed jurisprudence in these areas in a quite remarkable way as a result of this. But and also in India, you see that some of these public interest litigation cases, if you view them, I think that the typical case in India is maybe the case on the pollution in Delhi, ordering the buses to use cleaner fuel, and that this actually impacts on a lot of people. And it has many of these, so they have quite large ramifications, but they're fewer. And the political dynamics are more complicated, and the implementation of these cases are more complicated. And what we see is that in these cases asking for structural change or for policy change, there are two types, broadly speaking, two types of judgments being issued. In some of the cases, the judges will say, do this. So they will sort of give an order and demand the order to be implemented. And in South Africa, we see that, we were talking about it earlier, but we see that in cases where it's about extending to a new policy to a new group, or if the policy has sort of developed during this long litigation process, so the court is more escaping it, then that will often be the result. But in cases where new policy has to be developed, some courts will demand a change, but what we see is that what the courts sometimes try to do is to create a dialogue. They try to create a dialogue with political decision makers. They will say, for instance, in the Colombian Constitutional Court, in the case on internally displaced people, Colombia has the largest or second largest group of internally displaced people in the world, 4 million, I think. They said that the situation for this group is unconstitutional. It's an unconstitutional state of affairs. You need to do something about it. They set parameters for the process. They said you need to include, it must be an inclusive process. You need to include stakeholders of different kinds and develop a new policy. They did the same, actually, on health. On the health, in 2008, they said you need to restructure the health system. You need to restructure it. You need to make it unified, not one for those who can contribute and one for those who are subsidized. You must unify it, and you must get internal complaint mechanisms working. We can't have all these cases, and a lot of other orders. But then they also said you need to have a participatory process. You need to include people throughout the process and enable people to actually contribute. Enable different groups to contribute in the development of a new health policy. So this is a different way. This is a dialogical way of trying to use the court system to push the nudge or push or get the political action going. So then critics say that it's just nothing happens, it's just talk. And of course, it's a long, more drawn-out process. Sometimes it has strict time limits, sometimes it's not so strict. But what we see is that it often puts in motion very interesting social processes. Because, for instance, with regard to health in Colombia, there was a lot of social mobilization around health in the aftermath of this judgment. And I think that's also, so when we look at the effects, we look at the effects in terms of sort of the laws and policies and whether they're implemented in the material sense, but that's not the only thing that matters. In addition to the material effects, it's also important to consider the effects on the political process. What are the political effects of these judgments? Does it involve new groups in the political decision-making process? Do some groups get more leverage than they otherwise would from this process? And it's also important to think about the change of ideas. Is the way we talk about these issues changing? Is something that was just an unfortunate situation suddenly become a breach of a right? Does that matter? Does the way we think about social problems, are they changed by these processes? So these are the multi-dimensional effects that's important to consider. Okay, I'll wrap up. Okay, so now this becomes more complicated with more. What we see is that there are feedback processes from all of these in all directions. So this is a system that is moving. So it's not only that we need to, when we try to think about what is the role of the courts in these processes, it's not only that we need to sort of look at the ramifications, how the actors influence each other, and the strategic choices of the different actors. It's also that this goes on over time. It's an iterative process. So we need to, before we can pass a verdict, we need to look at the long-term process. So for instance, in Colombia, the thousands and thousands of litigation cases were what prompted the Constitutional Court to review its jurisprudence and decide the big judgments on reform of the healthcare system. So the long-term effect is different from the short-term effect. And this can go in all directions. It's not necessarily positive, but it could be. And also, it's important to realize that even if you lose the case, you might win the battle. Because litigation can be a very effective aspect of social mobilization. It requires research that is important for mobilization purposes and advocacy purposes. It requires the research to be put into an argument in a particular way. It creates a particular space in court for a dialogue involving different parties. So there are, and it often creates media attention and so on. So there are different factors that impact on these processes that make it important to not only consider the impact of the judgment, but of the litigation process as such, when we try to look at the role of courts and the impact of courts. That the role of courts as a site of struggle is as important in many ways. And then one aspect that has not been particularly discussed today, but this is also a very international process in many ways. Many of these cases are there are international linkages in many ways. Judges their opportunity structure is also the way their ability to make judgments are also influenced by what courts in by international law, what courts in other countries do. International courts, to some extent, it's influenced by, as I said, by litigants' arguments, and they sometimes get arguments from law schools in the US, or they get it from colleagues in other countries who have interesting cases, international NGOs who sort of make judgments available on websites and so on. You get funding internationally in many cases. Judges might want to have the international recognition that it gives. So there are a lot of international dynamics that are also important to consider in this. But I think that the basic point that I wanted to make today is that it's important not to have a too narrow perspective if we look at the sort of impotency or potency of courts, because it could be more or less than it looks at the first picture, depending on what happens later. Whether if you have a judgment and the politicians don't care and nothing happens in implementation, there is no follow-up, it's dead. It doesn't really go anywhere unless someone else in a different country or a different part of the country uses it the next time. If you have a litigation case going and a politician, government thinks this case is going to go against me, so I better jump now so I can get some mileage out of this social policy change. Then, as we are, sometimes they miscalculate and the judgment didn't go against them, but they still move. So there are different ways, but it's important to consider how these different actors and factors interact. So, I think my conclusion is that courts and judges can contribute both to limit implementation gaps and also to limit policy gaps. But long-term social transformation require political change. And litigation and adjudication of welfare rights cannot substitute for political change, but it can trigger, complement, and strengthen political processes. Thank you.
The floor is open. Yes.
This was absolutely fascinating, as sort of the afterlife of the law as a lawyer is something you don't see. Just 3 quick questions. One is that, so in the last chart you showed, it could well be that, judgments and the implementations have sort of negative feedback mechanisms on the movement itself. So there's a lot of literature, for example, that civil rights, de-radicalize the black movement, right? and Roe versus Wade, in some sense, in the US literature, de-radicalize, women's movement. So, there is this, we should be open to the possibility of the negative. Second, that, in the relationship between sort of, the judgment and its implementation, there's also a question of state capacity, right? Politicians might agree, bureaucrats might like the idea, but, the state might, simply not have, the ability to enforce. And I was just wondering what you think of, both of that.
Yeah. I think both your points are very, very important. And I think the first point is really, really important. And I think that is sometimes, I think there are expected effects and unexpected effects. And some of the unexpected effects are negative, but even if you get what you want, as you said, it might have a negative influence either on the movement who litigated or on others. So it could sort of win it for a particular group, but it could create more disturbances in the social system. And I think that's absolutely true. And I think that there has been a lot of debate also on the demobilizing effect. And I think it's something it's an empirical question, and I think it has to be looked at in each situation. I don't think it's, from what we've been seeing, I think you can't. It's not something you can generalize about. I think it varies with the context and also over time, I think. I also think that if you can use this mechanism to look at the trajectory in India of how the current laws are sort of, you can see how there are building blocks in public interest litigation over time, how that contributed to a rights discourse, more litigation, important judgments that are then building blocks for policy, but also activists who are involved in drafting. So I think that this type of process doesn't only go for one particular case, but it can show how different legal actions over time have a certain direction. Your second question on state capacity, yeah. I think that's absolutely true, and I think that is one of the reasons why that has been one argument for the dialogical forms of judgment. That it's sort of, if you're required to have stakeholders at different levels involved in the process throughout the planning, the realism is more likely to be there. So at least that's one of the ideas. There is. But it's also, I think, capacity is also about organization and about bringing actors together. I think one of the most fascinating cases that I know about is from Argentina. It's a pollution case. There was this Riachuelo River in Buenos Aires, which was polluted for 100 years, sort of thousands of polluters, 17 different municipalities, and very difficult to get anything done because of the fragmentation. And then you had a Supreme Court judgment ordering actually sort of the different parties to get together and do something and establish an authority and so on. It's not that, I mean, this situation is ongoing, it's there are things happening, but it's not a success as of yet, but it shows sort of how there are different ways of developing capacity through the judgment as well. But obviously it's a challenge.
Sorry, but a final question. The diagram also assumes that adjudication is an autonomous sphere, right?
Yeah.
I mean, for example, like in Stalin's court, compliance was 100%,
yeah.
But he just chose the judges.
Yeah.
So, that's also, I mean, you have to assume that the legal space is autonomous and then ask this question.
Yeah, and I think that's crucial, and I think that the legal-political relations are very important. And I think that, I sort of hinted at it a little bit before, but I think that if you look at the relationship between judges and government, it varies a lot. And I think that if you look at South Africa, for instance, there's a very different relationship between the Constitutional Court, for instance, but the judiciary generally, and the government, of sort of both realizing that there's only so much you can do, in a way, that there is a very sort of strong political party who's likely to be there for a long time, but also that they actually sort of, yeah, they're willing to give the government the benefit of the doubt, and they want to sort of see the government moving. But in many Latin American countries, when you interview the judges, they will sort of say that they just waste money anyway, and there's so much corruption, there is so much wastage, they can always do it. So, but it's also, of course, about it, because it's so often only one, sort of one more patient, you can also take one more. But there is also something about relationship, and obviously judicial independence is important. Both judicial independence and judicial capacity is also very important.
Very much for a very fascinating lecture. Two very short questions. The first one concerns the category politicians, bureaucrats, that it seems to me deserves to be unpacked a little bit.
Yeah.
We have cases of litigation which actually some politicians welcome because it will strengthen the bargaining position in a negotiation about where the priorities should go, for example. If you sue lower level governmental entities, they may explain that their failure to implement the right to food, the right to housing, the right to education has to do with allocation decisions made at the center that are not in favor of these rights being adequately implemented. And they may actually use these cases as a bargaining chip in an ongoing negotiation as to what gets funded by which level. So that's the first question, whether in your research you had identified interesting situations where this occurred. I shall have some more to say on this, I guess, tomorrow morning. The second question is that social rights, welfare rights are specific in that they require, to use an almost metaphorical expression, to move. They are not conservative. In other terms, people usually do not litigate just to have rights that are well enunciated and usually respected, complied with. They litigate for social change, as you said. Now, separation of powers is actually a system calculated to make change very difficult. Courts only protect existing entitlements. Parliaments are checked by constitutional provisions. The executives, in principle, must have the authorization of parliaments to act, and the budget is voted by parliament and so on. So this is, checks and balances. I wonder whether in social rights, for their adequate implementation and enforcement, we do not need a fourth branch of government. An agent that would be transformative in nature, that would be able to do, in a way, what the commissioners of the court do in the right to food case, or what national human rights institutions might do. In other terms, to be agents of social change that do something else than what courts, parliaments, executive are in charge of in a system of separation of powers.
Yeah. I totally agree. I think that your first point is absolutely valid, and it's also why, I mean, I've tried to indicate it by looking by making several different actors. By making several different actors, yeah, because I think that is crucial. And as Beth was explaining from South Africa earlier today, it can also be internally in a party. I mean, you can have different. I think generally it's quite well recognized that judgments, you need someone to run with them. You need someone to see them in their interest in order for them to have effect. I mean, then they can be really, really useful for someone. So I think that, or you don't have to, but it helps. I think your second point, I think, is one of the reasons why you've had this experiments and moves in some cases to dialogical processes, because I think many courts find it really problematic, particularly where, I mean, it also places them at the heat of politics. If they sort of repeatedly go in very controversial areas. So it's also, so I think that there are many reasons why, but also because it's complex and then because it requires funding and so on, and also because it's you want to, it's a way to make it sustainable and make people responsible for the changes. So I think that's true, and I think that it is actually, I don't know if it's always feasible, because it depends again on the dynamics. I think sometimes it might not be feasible to kick the political system into action, but I think that I think that in most cases it would be favorable if it's possible to get the political system moving. I think that it was also hinted at earlier today by one of the commentators that there are a lot of, in the name of good governance, we take away a lot from the ordinary political process. So it's on public consultation, it's sort of grassroots community organizations, it's different agencies, all kinds of bodies that take out parts from the state. And I think sometimes there are very good reasons to do it. And I think sometimes this can be really important components in a democratic structure, but it's also important to leave, to sort of get the political system to move in a constructive way, if possible. I think that is that's sort of the main, that must be sort of job number one, if possible.
Good evening. Hope you can hear me. Yeah. Yeah. I'm assuming this model is presupposing an unresponsive political system, from the previous slides. Correct me if I'm wrong. Or the fact that, courts are much more easier to approach than the political system, so people, just go and make a litigation. It's also extending the point that Olivier made that, if a group of politicians want something to happen, they, kind of sponsor a group to go and, approach the court and litigate, and, it comes through this process, which forces the hand of that system. But the problem I see here is, privileging this system of initiating change. The court system, the judges are ill-equipped to, properly analyze what kind of changes are needed.
To try and throw the ball back to the government, but force them to act on it, so that they actually make it. But in many cases, I mean, in all legal cases, the courts will hear evidence. And if the case is complicated, you can hear a lot of different experts, and you can have a discussion in the court. So I think that it's not necessarily, I think that the competence argument is not necessarily that different for all socioeconomic rights cases. I mean, all other kinds of cases can also be complicated. And I think that it's sometimes overestimated. I think some cases are really, really complicated and should be dealt with in representative bodies and other processes, but some cases are not that complicated and could be well suited. And the court is also able to sort of, I mean, it's groups that would not necessarily get their voice heard so easily in the political process, but who are affected by the decision, is more easily heard in court. So, for instance, for minorities, it could be very useful. And this is not necessarily an unresponsive system. I think all systems are, to some extent, unresponsive. I mean, even quite responsive political systems. I think there might still be reason why you want to litigate. I mean, it can also be, as I said, be part of a political campaign. And you might know that the system might not be unresponsive, but your case might be very unpopular. So you want to take it through the courts to see if you can win, and even if you lose, you get publicity, maybe something happens later. So.
The sort of flip side of judicial independence could mean that in a judge-centric system, the individual background that a judge comes from, maybe the social background, the political inclination of a judge, might have a bearing on his or her decision making. So first question is whether your research factors that sort of a difference in how one judge might behave in a certain situation than another judge. And second is, although there is something called a doctrine of precedent where one judge or a judge who's listening to something that has already been listened to in the past should follow the similar principle. A judge who's willing may always give their own reasoning to, move away from that position. So how do you, take care of that difference in opinion if you want to give a legitimacy to that system of judicial decision making? Because that might result in weakening of authority of that, that judicial system.
That's very important. It's really, really important. And I think it's extremely important that we're not rosy-eyed with regard to what courts do. Because that's also about power. It's also about it's not necessarily. I think that we tend to agree when there are judgments that we like. And then, but of course it's a dilemma. And I think I think there are good reasons why you don't want everything to be decided in the courts. So I think that, and I think sometimes it's also about being careful of what you wish for, because I think if you get very, politically, judges who sort of are very politically against social rights, for instance, then that will have a bearing. I mean, you have a lot of different issues, and it's also, of course, you have appeal systems, but it's a more fragile system in some ways than a political system, although in different ways. Yeah. But I think that what is interesting with judicial systems is that I think in some ways, I've been working a lot in African countries, and I think in some African countries, for instance, in Malawi, where I've worked a bit, sometimes you get surprised at how it's generally a quite fragile and weak political system, but the courts are holding up reasonably well. And I think that what you see is that the international dimension, the sort of international professional community and professional norms of judges are quite interesting. And it creates a professional culture that is a bit, that is also quite, has some advantages and is robust in some ways. But it is a concern, and it is important.
Thank you for a very insightful presentation, but it's a mammoth canvas, and you have succeeded in communicating in less than an hour, so that itself is a congratulatory point here. I have a kind of a question come comment. I must say I'm pretty skeptical on some, particularly on methodological things that you presented. It appears to me far more resource mobilization theory kind of thing. And I'm wondering actually, because of that particular kind of a frame, which itself is important, and I think the value is acknowledged. I'm wondering actually what happens if some of the actors who contribute to this mobilization that is already there is already changing. Say, for instance, the social action litigation, which is very much at the background to this. If you really look at human rights funding scenario, the NGO structures are changing, the development-led scene is absolutely going upside down in European context and elsewhere. So I'm really wondering then what happens to that politics in terms of accounting in change, number one. Number two, Bakshi and his work on Supreme Court and politics of India, in the sense, how do you locate the juridical politics at one level? I mean, in the sense, we also know, I suppose one way of saying public interest litigation is judicial populism, if you would like to see it that way. And we seem to have moved from that to a far more seriously political populism. And I think Partha Chatterjee and Lacklow are two different personalities and their work on political populism. I really wonder what happens to those aspects if you really need to account in this case.
Thank you. Very, very good questions. I think, again, it's also something about explaining things. Because I mean, this is, for me, this is an analytical, it's not a prescriptive, it's an analytical schema. And if the dynamics change, they change. And then the outcomes become different. And you get a totally negative outcome. So I think that in that sense, and I think that often happens. And I think that is also why it's important, because sometimes, often I think, it might look good here, and then it's not necessarily good at all. because as you can sort of win by lose, but you can also lose by winning. And I think, and there are a lot of dynamics. And I agree that it's a lot of sort of resource mobilization and so on. But for me, sort of, if you remember the first, sort of, if you go into if you sort of explode the adjudication choice situation, if you will, I think one of the things that I think is really, really important is to keep the law in there. Because I think that's what political scientists often, I mean, lawyers tend to, at least in Norway, tend to sort of not really see the political dynamics all that clearly. But political scientists don't usually get the law. So it's all about rational choice. And I think that it is important to realize that most people actually want to do a good job. Most people actually want to do the right thing. And I think that a lot of judges, there are all kinds of things that happen, but sort of people, I think that at least my experience in interviewing sort of Supreme Court judges in many countries, I mean, they really, really think really hard on how they can get a very good judgment. And it is also about it is a lot about the law. And it's about sort of, so I think that it's important to take, but it's the same also if you look at sort of political actors and if you look at bureaucratic actors, that you actually need to understand the situation where they make their choices. What is it that limits what's the barriers that restrain and that condition the resources that condition their choices? And I think that's one of the main, that's sort of one of my main points, that I think that's something that we need to look at much more clearly. And I think that's also with political actors, sort of when is it that a judicial decision can tip the balance in one way or the other? Sort of what is it, sort of, where if you try to understand why things happen, which is what is the main purpose of this, is to try and sort of analyze courts in context.
Thank you. I think Sitaram has asked part of my question, but I'm coming from a perspective where I wish to ask if there's an assumption here that we access the judiciary from an absolute perspective that you can actually access and secure social justice, or is the judiciary a contested space, a very complex and contested space, which is essentially a tactical terrain in advancing social justice? And I ask this acknowledging the schema that you have evolved in locating courts. And we all know, and you also said we can't be rosy-eyed about these neat lines that we draw in the way things interact, because we all know systems are much more political, in fact, deeply political, and courts operate within that deeply political space. So it leaves open the question of advancement of social justice. And what should be the kind of guideline to navigate this space? One goes with hope and belief, or does one go in a more tactical sense?
I mean, your insights are, I share your insights very much. I mean, of course there are contested spaces. And of course I think that sort of the basic premise is that law is frozen power in a way, and that change is difficult. But so I think that, but I think that what we do see is that sometimes there are possibilities. Sometimes actors are able to use the courts, and sometimes there are judicial actors who are themselves. I think that's maybe the Colombian Constitutional Court is in some periods is one of the best examples, who actually sort of have an agenda for social change, and who see themselves as counterbalancing an unresponsive political system very explicitly in certain periods. And I think that, so it varies. It depends on the context and the personalities and the situation. But I think that to, in general, perceive courts as as spaces that are sort of the best route to social change, I think that is a very risky strategy. I think that sort of both, for many reasons, both because courts might decide very differently, and it's very difficult to predict, but also because it's very difficult to know what happens with the judgment afterwards. So it is, I mean, it is a political process. It is that it acts within. I don't know if it answers to your question, but.
We're getting close to the end of this lecture, but you can ask the question. Possibly that will be the last question, yeah?
Thank you for this lovely presentation. I had a question with regards to the nature of change itself. Given the fact that the judiciary cannot really go beyond just interpreting rights and can't really stretch too much and overstep on the jurisdictional shoes of executive or the legislature, to what extent is this model helpful to explain a radical change? And to what extent is it limited to explaining only incremental changes in social policy?
I mean, sometimes it's fascinating what can be done. So, and then sometimes courts are very creative in sort of devising remedies that are new and also sort of types of jurisprudence that is new. And I think that, so I think that's also why this is such an interesting field, because there is also space depending on the context. And it's also sometimes you have a very powerful meeting of minds in the court cases. It's sort of very fascinating arguments that will be really challenging. Sometimes you can see, if you read the judgments, again, I think that Colombia is particularly in some ways interesting, that you have they're really, really trying to deal with a lot of the political theory questions, sort of really trying to take on, but also in some of the South African judgments and that I've known and so on, they really, really try and take account of real difficult theoretical and political questions and advance the field. And I think, so I think that it's sort of it's like, someone mentioned Hannah Arendt earlier today, and I think that her sort of concept of action, that you in a way realize a very small possibility and then things go in a different situation, that's what sometimes happens. So sometimes the judgment can make, because of the situation where it happens, history takes a different turn. But of course you can't, yeah.
Thank you, Siri, for the most riveting lecture. And, so I guess we end the session here. Right?
Tomorrow at 9:30.
Yeah, tomorrow we start at 9:30 in the morning. We expect to see as many of you who are here and some more, especially the students, actually.